Very good morning everyone. Well, I am Swati Bajaj and I am my module topic is winding up of the companies, its need, grounds and effects. As we all are aware of this fact that now we have a new companies law, that is the Companies Act 2013, and it has replaced an old age companies law of 1956. In the new Companies Act, several new sections or provisions were inserted and several old provisions were deleted. We have total of 470 sections in the new Companies Act 2013. So, as my topic is winding up of the companies. So, a company is an artificial body, artificial as well as an independent body. A company, whenever a few members came together to form a company, then they have to go through a very huge process to establish their company. So, the question of winding up is very serious, because the persons who are coming together to make their company, to establish their company, why they want to wind up their company. So, winding up is a process whereby the existing company's affairs are brought to an end. It is a very complex situation where the companies which came into existence aspire to grow higher with the passage of each day, in fact each second. They turn off their entire business, and this winding up can be voluntarily as well as can be compulsory. Voluntary winding up can be understood at the companies, if the members of the companies want to end up their business. This is genuine, this is natural. But where the compulsory winding up came into question, then the question is why, what are the grounds, what are the factors which lead a company to wind up their business. So, basically it is a process by which the properties of the company are administered for the benefit of its members and creditors. A company is formed not only by the members. There are few persons like creditors who invest their own money in the company, and if they invest their money, then obviously they want some good return after that of their investment. So, whenever a company fails to give them the good return, or whenever the company fails to satisfy their creditors, then that leads the very complex situation for the companies where they may face the winding up of their own establishment. In winding up is also known as a liquidation, because here the person appointed for administering the assets and liabilities is called liquidator. If there is a compulsory winding up, then the liquidator is appointed by the tribunal, that is the company law tribunal, under section 275 of the Companies Act 2013, there is a new company law. In case of voluntary winding up, the liquidator is appointed by the company itself by passing a special resolution in a general meeting, and that is under section 310 of the Companies Act. So, on liquidation, the company's name is deleted from the list of the companies by the registrar of companies, and the same is published in the official gazette. As I already told you that there are two types of winding up: compulsory winding up and voluntary winding up. Compulsory winding up is also known as winding up by tribunal, because there is involvement of tribunal in it. Section 270 of the Companies Act 2013 provides these two modes of winding up. So, now I will tell you the basic difference between these two modes of winding up, compulsory as well as voluntary. In case of compulsory winding up, petition is filed before the tribunal either by the company or by any creditor or by the contributory or by registrar or any person authorized by the central government on that behalf. This is section 272 of the Companies Act 2013, which provides the persons who can file petition in the tribunal for the winding up of the company. Whereas, in the case of voluntary winding up, section 304 of the Act provides that no petition is required, no petition is filed before the court or the tribunal. In this case, what happens? The company passes a special resolution in its meeting, or it passes a general resolution in case of expiry of the period of its duration. Suppose if a company is formed for a specific purpose, and to in the article of association, as we all know that the article of association and memorandum of association are two important documents for the formation of a company. If they have mentioned that they are establishing their company for a specific purpose, and after the completion of that specific purpose they will end up or they will demolish their company, then it is a very general or a genuine reason that when they complete their specific purpose, they will wind up or they will demolish the company. So, this is the voluntary winding up given in section 304 of the Companies Act 2013. Now, in case of compulsory winding up, the tribunal at the time of passing the order of winding up appoint an official liquidator. Please note that here is an official liquidator or the liquidator from the panel maintained by the central government. This is given in section 275 of the Companies Act 2013. Whereas, in the case of voluntary winding up, the liquidator is the company's own liquidator from the panel prepared by the central government. Here the panel is of the central government, but who appoints the liquidator? It is a company. This is given in section 310 of the Companies Act 2013. Third difference is that in case of compulsory winding up, the official liquidator can be removed by the tribunal on the grounds which are mentioned in section 276 of the Act. Whereas, in the case of voluntary winding up, the company liquidator can be removed by the company itself if it is appointed by the company, or by the creditor if it is appointed by the creditor, on the grounds mentioned in section 311. Now, as we all know that a company is established and a company is administered by two main vital organs. One is a member of the company, they are the directors or the shareholders, and another one is the creditor who invests their funds in the company. So, if the company itself want to wind up their business, then in that case company itself can appoint a liquidator, and if the creditors want to wind up this business, then in that case creditors have the right to remove any company liquidator if they want. Another main difference is that in case of compulsory winding up, the order of winding up of the company shall operate in favor of all the creditors and all contributories of the company as if it had been made out on the joint petition of creditors and contributories. This is given in section 278 of the Companies Act. While in case of voluntary winding up, section 309 says that the company shall from the commencement of the winding up cease to carry on its business except as far as required for the beneficial winding up of its business. So, there is a main difference between the compulsory winding up and the voluntary winding up, as there are two modes of winding up. It means that the winding up of the company can either be compulsory or can either be voluntary. Now, further, even the voluntary winding up is of two types. Again, I will repeat the same, that a company is administered by two main vital organs. One are the members of the company, it is the shareholders and the directors, and another is the creditors. And I had told you that voluntary winding up can be enforced by either the members or the creditors. So, the voluntary winding up is also two types, members voluntary winding up and creditors voluntary winding up. In case of members voluntary winding up, declaration of solvency is made by the directors, while in case of creditors voluntary winding up, there is no need of such declaration. In case of members voluntary winding up, only meeting of member is called, while in case of creditors voluntary winding up, meetings of both the member as well as the creditor is called. In case of members voluntary winding up, the liquidator is appointed and remuneration is fixed by the company itself, while in case of creditors voluntary winding up, the liquidator in fact is appointed by the creditors and remuneration is fixed by the committee of inspection. In case of members voluntary winding up, no committee of inspection is appointed, and I already told that in creditors voluntary winding up, committee of inspection is appointed. In case of members voluntary winding up, the liquidator can exercise some powers with the sanction of a special resolution of the company, while in case of creditors voluntary winding up, the liquidator exercise powers with the sanction of the tribunal. In case of members voluntary winding up, meeting of members is called on completion of procedures or proceedings of winding up, while in another case, that in the case of creditors, meeting of members and creditors is called when the proceedings for the winding up has been completed. So these are the main difference between the members voluntary winding up and the creditors voluntary winding up. So till now we have discussed the concept of winding up. What is the winding up? The two modes of winding up, that is the voluntary winding up and the compulsory winding up, and the two further modes of voluntary winding up, that is members voluntary winding up and the creditors voluntary winding up. Now, as I already told that a company came into existence with an aspire of growing higher and higher, with an aspire or aim of earning huge and huge profit. So what are those situations? Obviously there must be some serious situation, serious reason or grounds which force the company to wind up its business. In voluntary winding up there are no such grounds, as it is it shows the willingness of the company to wind up their business. But in case of compulsory, when the word compulsory arises, then it shows that there is some force behind the winding up of the company. There is not any willingness of the company. So we will now discuss the grounds of winding up of the company, compulsory winding of the company, where there is an involvement of the tribunal. Section 271 of the Companies Act 2013 provides various grounds on the basis of which a petition can be filed in the tribunal for the winding up of the company. The first and the most important ground is that inability to pay debts. Inability to pay debt itself clearly clarify its meaning that whenever a company fails to pay its debts, a company is always having some debt from due, because a company is something which runs on the investments made by other persons, and the duty and the responsibility of the company to satisfy those investments. But if the company fails, then what? Obviously, if the company fails to pay their debt from the pocket of the company, then the consequences have to be suffered by the company itself, not by the members. Members will do only one thing, they allow the winding up of the company. They will never pay their debts of the company from their own pocket, because company is one thing and its members is another thing. They both are separate bodies. So in case of inability to pay debt, the compulsory have to suffer the consequences, and the consequences, the petition for the winding up of the company. So section 271 of and subsection 2 provides that the inability to pay debts primarily arise under three circumstances. First, where the company fails to clear the debt of the creditor within 3 weeks immediately preceding the date of demand for payment being made. It means when the creditor has made a demand to the company that the company should pay their debts, and from the demand 3 weeks preceding from the date of demand, 3 weeks have passed, then in that case, after the completion of those 3 weeks, the creditor can immediately file a petition in the court or tribunal for the winding up of the company. Second is where execution or other process issued on a decree or order of any court in favor of the company is returned unsatisfied in whole or part. So if there is any dispute against the company in the court, and a court has passed a decree against the company, and company fails to satisfy the decree, then in such a case court can suo motu take an action, suo motu plus on any application made by the decree holder. So the court can proceed for the winding up of the company. Thirdly, where it is proved to the satisfaction of the court that the company is unable to pay its debts. Now these three are the main circumstances, but there is a difference between these three, that in the first two, firstly when the company fails to pay on the demand of the creditor, and secondly where the execution is unsatisfied. In those such cases, it does not mean the company is lack of funds or the company is unable to pay. It does not show the inability of the company or the inability of the company. It just shows that company is not paying, whatever be the reason, they do not want to pay, or there are some personal reason, or there can be some bona fide grounds on the basis of which they are refusing to pay the amount. But in the third case, it is clearly mentioned that when the company is unable to pay its debt. A petition for winding up on the ground of inability to pay debts must contain all the relevant information about the debt. The petition must disclose the assets of the company and whether they are sufficient to meet the liabilities, including contingent and prospective liabilities. Further, the petition must also disclose the position of fixed assets as well as the valuation of plant and machinery of the company. Now, where a debt is a bona fide disputed by the company and the court is satisfied with the company's defense, a winding up order will not be made. So, even if the creditors or the tribunal itself, suo motu, have taken an action against the company for the winding of the company, it does not mean that the company will come to an end. There can be some bona fide reason on the behalf of the company that why they are doing so or why they are not doing so. So, in case of K. Apparao versus Sarkar Chemicals Private Limited, the Andhra Pradesh High Court held that where a company has a prima facie sustainable defense or a bona fide dispute of its obligations to discharge the alleged debts or liabilities, there the court may not entertain proceedings for the winding up of the company. And once there is an admission on part of the respondent company of liability of dues payable, then a petition under section 273 cannot be dismissed on technical grounds. Company courts can exercise their discretionary powers of dismissing the petition even before issuing a show cause notice regarding admission. Further, despite of repeated demands, if a company neglects to pay its debt, here the word is company neglects to pay, it will be considered as an inability of the company to pay its debts and an order of winding up can be passed by the court. By non-payment of the undisputed debt within the period of statutory demand, the company is deemed unable to pay its debts, and where the company is unable to pay its debts, winding up ought generally to follow in public interest. Another ground of winding up is special resolution, that is special resolution passed by the company's member in a board meeting. A company may by special resolution resolve that it be wound up by the tribunal. The resolution may be passed for any cause whatsoever. However, the tribunal must see that the winding up is not opposed to public interest or the interest of the company as a whole. There is a case on this point, a New Kerala Chits and Traders Private Limited versus Official Liquidator. This is a case of 1981 in which it has been observed by the court or by the tribunal that the tribunal has a discretion in the matter and is under no obligation to order winding up merely because the company has so resolved. Another ground for the winding up of the company is that if the company is working against the national interest. National interest is something which is the most important than anything else. Even the Constitution of India protects the national interest as well as they give the duties to the citizen of the country or the non-citizen also that they must do something in favor of the national interest, but not against. Anything done against the national interest will be condemned. Here also, if the company work against the national interest, then in such a case it can be wound up by the tribunal. So, if it is said that if a company has acted against the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, then in such a case the company can be wound up by filing a petition in the tribunal. Next is the failure of scheme. Failure of scheme. Now, what is scheme here? Scheme here means that if the scheme of revival and rehabilitation is not approved by the creditors, then the company administrator shall submit a report to the tribunal within 15 days and the tribunal shall order for the winding up of the sick company. The tribunal on passing the order of winding up shall conduct the proceedings for winding up in accordance with the provisions of chapter 20, that is section 271 subsection 1 clause D. Another important ground is fraudulent and unlawful affairs. The term itself explains its meaning that whenever a company conducts any fraudulent or unlawful affairs, then in such a case the company is not the tribunal will never allow the company to continue its business. If on an application made by the registrar or any other person authorized by the central government by notification, then the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner, or the company was formed for fraudulent and unlawful purposes, or the persons concerned in the formation or management of its affairs have been guilty of fraud, misfeasance or misconduct in connection therewith, and that it is proper that the company be wound up, then in such a situation the tribunal may, on a petition filed by any authorized person, can be the contributory, can be the central government itself, or a person authorized by the central government, or it can be the registrar. The tribunal may pass an order for the winding up of the company. This ground is mentioned in clause E of section 271 subsection 1 of the Companies Act 2013. Another major ground is default in filing financial statements. As we all know that the company has to file their financial statement with the registrar of the company. Registrar of the company is a very important person. In fact, it is a person who registered the companies in the list of companies register. So, if the company has made any default in filing the registrar its financial statement or annual return for immediately preceding 5 consecutive financial years, then in such case the registrar may file a petition in the company law tribunal for the winding up of the company. Another ground is just and equitable. Just and equitable, it is a ground which involves in it various other things. That any reason which the tribunal find as just and equitable, then the tribunal may pass an order for winding of the company. So, when the tribunal is of the opinion that it is just and equitable that the company should be wound up, then the tribunal may order the winding up of a company. The circumstances in which the courts have in the past dissolved companies on this ground are as follows. So, these grounds are not that which are mentioned in the Companies Act 2013. The grounds I am now further going to discuss with you, which are the part of this just and equitable ground. These are the grounds, or these are based on the precedents, that is which the court or the tribunal have already appropriated or used. First is the deadlock. Deadlock is when there is a deadlock in the management of a company, then it is just and equitable to order winding up. Although a company is a separate body, an independent body, an artificial body known by itself, but it is the members, it is the management who administer the affairs of the company. And if there is any deadlock between the management of the company, then how will the company survive? Because those persons which are handling the affairs of the company are not in a position or are not in a good relation with each other, or if there is any other circumstances, then in such a situation the loss has to be suffered by the company itself and not by the members. Then in such a case the tribunal find it just and equitable that the company should be wound up. Next is the laws of substratum. Laws of substratum means basically it can be explained as the laws of balance. So, when a company is formed, it is formed or established for an object, for some objects. Objects can be specific and they can be general, but they are mentioned in the articles of association or the memorandum of association, the main documents of the company. But when a company has failed to materialize the main objects for which it has been established, then in such a case the basic asset, the base assets of the company is lost. So there is no reason to leave that company in the market. So in such a case also there is a just and equitable ground for the tribunal to wind up the company. So the important illustration here is the case of German Date Coffee Company Re. It is a case of 1882, where a company was formed for the purpose of manufacturing coffee from dates under a patent which was to be granted by the government of Germany. I repeat, here a company was formed for the purpose of manufacturing coffee from dates under a patent which was to be granted by the government of Germany, and also for working other patents of similar kind. The German patent was never granted and the company embarked upon other patents. But on the petition of a shareholder, it was held that the substratum of the company had failed and it was impossible to carry out the objects for which it was formed, and therefore it was just and equitable that the company should be wound up. So obviously when a company which is running on a certain rope and if it lost its balance, then a company will automatically fall down. Another is losses. Losses simply mean that if a company is suffering a loss or if the company is not earning profits. Situations are different. Suffering loss is one thing and not earning profit is another thing. But when a company cannot carry forward its business except bearing the burden of losses, then it is just and equitable for the company to be wound up. The Bombay High Court observed in the case of Shah Steamship Navigation Company Re. Shah Steamship Navigation Company Re, the case of 1901. In this case, the court has observed that the court will not be justified in making a winding up order merely on the ground that the company has made losses and is likely to make further losses. Another important point is oppression of minority. This is a very important point, oppression of minority. Now, who is this minority? Here minority is minority shareholders. The members of the company are divided in two parts, directors and shareholders. But this director and shareholders, directors are also the shareholders of the company, but they are director because they are controlling the management, they are controlling the affairs of the company. They are considered in the they are considered under the majority shareholders, minority shareholders. Both have invested the money. Majority shareholders are those who are in the control, who is having controlling power in the company. While the minority shareholder, though, who don't have any controlling power in the company, but they are the investors in the company, so they are holding a share of the company. So oppression of minority means that whenever a company indulge in any misfeasance or in any unfair dealing which makes the minority shareholder to suffer or which is against the interest of the minority shareholder, then in such case minority shareholder have the option or have the option that to claim and went to the tribunal and ask for the winding up of the company. So it is just and equitable to wind up a company where the principal shareholders have adopted an aggressive or oppressive or squeezing policy towards the minority. It has been observed in Tivoli Free Re case. It is a case of 1972. I repeat, Tivoli Free Re, that where more than 70% of the company's funds were being used for objects wholly removed from anything within the memorandum, and 93% of the shareholders wished to dissociate themselves from the new objects, the company was ordered to be wound up. Another is the fraudulent purpose. If the company has been conceived and brought forth in fraud or for illegal purposes, then it is just and equitable to wind up the company. In Universal Mutual Aid and Poor Houses Association versus A.D. Thopa Naidu. I repeat, Universal Mutual Aid and Poor Houses Association versus A.D. Thopa Naidu, the case of 1933. Here the Madras High Court observed, where the main object of a company is the conduct of a lottery or any other illegal purpose, the mere fact that some of its objects were philanthropic will not prevent the company from being ordered to be wound up as being one formed for an illegal purpose. So, if a company formed for an illegal purposes whose main or basic objects are illegal or unlawful, then in such a case any philanthropic activity or action or nature will not prevent the company from being ordered to be wound up. So, these were the basic grounds on the basis of which the compulsory wound up can take place. Now, we will discuss the consequence of winding order. When a company who is running since a long time and suddenly they are going to demolish or they are going to wind up their business. So, obviously, there are some consequences. There are people who have to suffer the loss or the consequences of the winding up. The main consequences are that the order of winding up is deemed to be notice of discharge of the officers, employees and workmen of the company, except when the business of the company is continued for the beneficial winding up of the company. This is given in section 277 subsection 3 of the Act. Another major consequence is that all actions and suits against the company are stayed unless the tribunal gives leave to continue or commence proceedings. Further, any suit or proceeding pending in any other court shall be transferred to the tribunal in which the winding up of the company is proceedings. So, these are the major consequences. Further, the order of winding up operates in the interest of all the creditors and all the contributories, no matter who in fact asks for it. Section 278. All the powers of the board of director cease and the same are then exercisable by the liquidator. On the commencement of winding up, the limitation remains suspended in favor of the company till 1 year after the winding up order is made. This is given in section 358 of the Companies Act. Any disposition of the property of the company and any transfer of shares in the company or alteration in the status of members made after the commencement of the winding up order will be considered as void. This is given in section 334 of the Companies Act. Further, any attachment, distress or execution put in force without leave of the tribunal against the estate or effects of the company after the commencement of the winding up shall be void, but not for the recovery of any tax or impost or any dues payable to government. Further, any floating charge created within 12 months immediately preceding the commencement of winding up is void unless it is proved that the company after the creation of the charge was solvent. Now, these were the consequences of compulsory winding up. Now, the consequences of voluntary winding up. Three main consequences which have to be faced by the others in case of voluntary winding up. First is effect on the status of company. The company shall cease to carry on its business except if it is required to secure a beneficial winding up. There is a case, that is Wills versus Association of Universities of British Commonwealth. This is the case of 1964. It was observed in this case that beneficial winding up is not confined to financial benefit only. It may be for reconstruction and the business may have to be carried on so as to facilitate the smooth taking over. Board's power to seize. On the appointment of the liquidator, all the power of the boards of directors ceased and went into the hands of the liquidator. Then avoidance of transfers. This is section 334 of the Act. All transfers of shares and alterations in the status of members made after the commencement of winding up are void unless sanctioned by the liquidator or the transfer is made to the liquidator. Last but not the least, discharge of employees. Section 334. A resolution to wind up voluntarily operates as notice of discharge to the employees of the company. So, this it was a basic discussion on the topic of winding up the company, its needs, its grounds and its effects. Thank you.